others from the CFA Sri Lanka chapter, which I hold in very high esteem for organizing this session at a very challenging moment in our economic or in our history. Despite the challenges we face, I believe it is opportune moment to keep the discussion around these subjects continued, or have these discussions on a continuing basis, so that at the appropriate moment when the situation improves and the country is ready for a framework for the implementation of statutes like these, we will be able to take off because of the significant economic development potential this kind of personal data protection kind of legislation brings into the country's ecosystem. So thank you very much to the CFA local chapter for organizing this session. I can be heard clearly, Shanka, right? I can be heard clearly.
Jant, yes, very well.
So in terms of background and context and how at that time in 2018, 2019, when the urgency for this arose somewhere around mid-2018, these are some of the factors that were brought in to the table. With Sri Lanka investor forums in Europe, in UK and other parts of the globe, when we had trade shows in 2017-18 period, one of the biggest impediments for attracting high-end investors to Sri Lanka at the time was, amongst other things, of course, there were other factors that had to be addressed, but amongst many things was the need to protect personal data of individuals in a manner consistent with international standards. When it came to the tourism promotion and such other drives and efforts by Sri Lankan companies, Sri Lankan tourism authorities in other parts of the globe, again, the factor that inhibited the potential for Sri Lanka to reach out to a wider stakeholder group was the lack of a data protection legislation. The need for data protection also arose due to the fact that international instruments like the WTO requires the protection of privacy of individuals in relation to processing and dissemination of personal data that has been there for some time within the framework of the General Agreement on Trading Services. And in that context, also this became a moot point, not only for improving trade relationships, it also became a moot point of discussion, for instance, at the Singapore-Sri Lanka free trade agreement negotiations at that time, led by late Dr. Kallegama. We were part of the group that drafted the chapter on the electronic commerce component of the Singapore-Sri Lanka draft FTA. In the negotiation, one of the key points was protecting consumers in the digital era and impediments Sri Lanka would have in terms of cross-border trade and facilitation if we don't have adequate and meaningful laws. So this became a point of, at one point, some kind of a non-tariff trade barrier for Sri Lankan companies entering various markets. So this was one of the reasons why at that time we had a extensive stakeholder discussion in 2018, and in 2019 our ministry was vested with the mandate to draft a piece of legislation that would meet international standards. So the process originated from that point onwards, and we continued on that journey, looking at global standards, which I have highlighted under the second bullet. What was important is that we had some foundation coming from Article 14A of the Constitution, basically the right to information provisions, where there are safeguards even to protect data, and that framework has to be established by written law. So we need to have a written law frameworks to ensure checks and balances vis-a-vis all kinds of other rights that are available under the Constitution as well. In terms of process, Shanaka mentioned about the extensive discussions that were conducted. We had a very unusual process compared to other laws which are drafted in the traditional law drafting domain. Usually, the drafting of legislation is done behind closed doors by state sector only. Here, we involve private sector, and it was a truly a public-private partnership where representatives from Ministry of Justice, the Aegis Department, Legal Drafts Department, and we had people from private sector working together collaboratively and trying out provisions as we went through the process to see what is viable and what is not. So we had experts brought in from private sector, work together with government, and we took an early decision that the drafting process would be done in such a way that every single version will be available online right from the beginning. So we had the very first version published as a framework document in June 2019. The legal draftsman's first draft came out on the 16th of September 2019. That was also published. And the 3rd of October, we had a further upgraded version from the legal draftsman that was all published. Right through that process, there were extensive stakeholder consultations. And in the latter part of 2019, in December 2019, this was submitted to Cabinet to obtain in principle approval. Now, that was done without any restrictions or impediments, and right through 2020 and up to mid-2021, the Attorney General's constitutional review with legal draftsmen went through multiple iterations, and all these versions were published. And then the first cabinet-approved bill version was published in November last year. And then this was placed in the order paper on the 20th of January this year, and then debated and went through a parliamentary consultative process and approved without a vote, and subsequently certified by the Speaker. Now, what is important is that this bill contains certain very unique principles which are quite legalist. I'll not try to be legal because of the non-legal audience here. But if you were to download a copy of the available act and at least read through the first page, you get an understanding through the preamble what this bill is about. It's a law, it's a piece of legislation to regulate the processing of personal data that has been defined, and to identify and strengthen the rights of data subjects, and then to establish a data protection authority. And then in the preamble, it talks about the need to facilitate the growth and innovation of the digital economy in Sri Lanka, whilst ensuring the protection of rights of the data subjects in relation to personal data protection. And then another important principle highlighted in the preamble is the necessity to improve interoperability among personal data protection frameworks, as well as to strengthen cross-border cooperation amongst personal data protection enforcement authorities. So this law is about not having something in Sri Lanka isolated from the rest of the world. We needed to have a framework that was compatible and was interoperable with what was available with global standards, and to strengthen cross-border cooperation, to facilitate cross-border data flows, basically cloud hosting of data, which I will touch specifically. And this law is entirely about a broader framework to support innovation in the digital economy. So personal data has been defined in the law to cover this. I will share these slides, Shanaka, and to Anura later today so that you can distribute it. So personal data has been defined to mean any identifier associated with the data subject, such as identification number, name, address, financial data, location data, even online identifiers with a hashtag or whatever. Then, of course, you have other factors which are identified here. Interestingly, we have a separate definition for something called special categories of data, which would cover biometrics, fingerprinting, iris, your genetic data, health data. And that category of data has to be protected more stringently. And that is why there's a separate definition for something called special categories of personal data. So there's a definition for personal data and another definition for special categories of personal data. Data subjects have been defined as identified or identifiable natural persons, alive or deceased, to whom personal data relates. So remember, this law is not about company data, corporate information, which is protected or regulated under the Companies Act. Then you have under the listing rules, we have the SEC law that regulates information governing certain classes of activity. Then you have the Banking Act. So there are separate laws, and then we have Intellectual Property Act that protects intellectual creations like copyright, trademarks, patents, etc. This law is about protecting personal data. So basically, even in a company registry scenario, the company you get legal protection when you register a company, and the registration details of a company are available in the company registry. Anybody can file a request and obtain the articles of a company or find out who the directors of that company are. So that is possible. That entire process cycle is governed under the Companies Act. Here we talk about entire new framework for the protection of personal data of data subjects and how they can be processed in a lawful manner so as to do your business and regulated activity in a seamless manner. So in terms of application of the Act, it's important to note that this Act does not only cover processing in Sri Lanka. It takes care of processing of personal data either in Sri Lanka, partly or wholly in Sri Lanka. So even outside Sri Lanka, processing is covered, and would take care of scenarios where entity, which we call a controller, I'll come to that in a minute, engages in targeting individuals in Sri Lanka to offer goods and services or monitor behavior, including profiling in Sri Lanka. So all that is usually covered in many data protection laws. This is no exception, and this takes care of a broader segment of organizations like some of the digital services platforms that offer goods and services to Sri Lankans. It can be even a cryptocurrency exchange that you're dealing with in the present day context. I know many people are doing that kind of work. So even those entities that provide a service offering being outside the Sri Lanka would be covered under, would have to adhere to certain minimum standards under this Act. One point to note is that under this Act, we have a grace period for implementation. This was a moot point of debate, especially within the community of the Ceylon Chamber of Commerce and some of the other stakeholders who said that this law should not come into operation the moment the speaker certifies it, but there should be a grace period. So grace period is 18 to 36 months. So we have enough time basically. So, but I'm happy that CFA is getting people ready with this to have an awareness about it, rather than waiting for 18 months to get ready. So when the country situation perhaps improves at that point, when a data protection authority is established, there will be an opportune moment to discuss the details further, maybe at a face-to-face session. Now, to whom this law would apply is again area of definition. We have something called a controller who has been defined. It can be a company, a public corporation, a public authority, a ministry department, a bank, or any entity that decides the purpose and means of processing. Any body who collects, any entity, NGO, it can be even a political party or financial institution that collects our personal data and decides the purpose and means of processing that data would be a deemed controller under this act. And the law requires certain duties and functions to be fulfilled by a controller. Processor can be a natural law legal person who processes personal data on behalf of a controller. So I have given some classes of activity in the center column here that broadly indicates controller processor relationships in the context of day-to-day life cycles. A citizen going and giving our data to the ID card office, which processes our personal data in order to issue identity cards. We go and provide all kinds of information to either a public school or a private school. Children's information together with the guardian and parent information, including our mobile details. So they become a controller. Then you have a supermarket chain. We go and subscribe to a loyalty program. Then the supermarket becomes a controller. So all of this, then a bank that collects our personal data goes to the KYC process, and then that financial institution would process that information that we give them in order to provide us a service. A telco would do the same. All those would become deemed controllers, and many of these controllers enter into contractual partnership with other people, and that kind of entity would become a processor that acts on behalf of the controller. So this law broadly covers that kind of framework and how our data would be protected within this kind of equation in our economy, right? Whether it's government or private sector or even a club or institution where we provide our data. So it's a vast area, applies across multiple sectors, including to our professional organizations. I know CFA local chapter may be having personal data of individual members. So they are processing that information may have to be governed by this act. So even the CFA would become a controller for all purposes, right? So it's a very interesting thing. So in terms of salient features of the act, this has certain principles for data processing and certain principles that govern rights of individuals. This entire law is mainly about the rights of data subjects, and then we have certain obligations on controllers and processors with regard to how they should manage personal data. So I'm not going into all of them. This has a complex array of principles, but I'm just going to flag a few of them. So part one of the bill, ladies and gentlemen, has certain fundamental principles of processing personal data. And those principles involve ensuring accuracy, principles of storage limitation, ensuring integrity and confidentiality of that data, and then principles of accountability, transparency. But I will touch firstly on the principle of lawfulness. What would constitute lawful processing of personal data? So as a controller, whether it's a CFA local chapter or a bank or a mobile company, when they collect personal data, they have to they would be deemed to be processing it lawfully if they process it in compliance with the conditions in Schedule 1. If a controller is processing special categories of personal data, they have to do in accordance with any of the conditions in Schedule 2. And then, of course, we have certain grounds under which consent can be given, that is spelled out in Schedule 3, and so on and so forth. So if you look at the extended intent and meaning of this principle of lawful processing of personal data and refer Schedule 1, you will see consent of the data subject being just one of the conditions, right? The personal data data subject has given consent to the processing of his personal data. Then you have processing of personal data carried out for the performance of a contract to which the data subject has agreed to. And then thirdly, you have another option. Processing is done in compliance with the legal obligation to which the controller has to comply with. So banks, for example, have to comply with requirements under the Financial Transactions Reporting Act. Banks have to report information with regard to certain suspicious transactions to the FIU. So that would amount to lawful processing that they would have to do in compliance with the law, and that would be done and sharing personal data, let's say with FIU in compliance with the Financial Transactions Reporting Act, would amount to a lawful processing within the meaning of the Data Protection Act, right? And so when it comes to a telco or a bank wanting to process our information to provide a value-added service, that would be lawful processing if they have obtained not only consent, but if they are doing it in pursuance of a contractual obligation to which we have entered into. Same would apply in a capital market scenario where Colombo Stock Exchange or the CDS process personal data for purposes of sharing it with any of the entities that are connected with its business-related functions. And for that purpose, contractual frameworks will have to be examined and so on and so forth, right? In terms of other principles, I have highlighted confidentiality. I will not go into too much of details. There are methods to ensure confidentiality through encryption, access control measures, anonymization, etc. But most importantly, Section 11 under Part 1 contains the parameters of a privacy notice. I know many organizations in the financial sector, amongst unit trusts, stockbrokers, investors, many of these organizations have broad range of privacy notices which are prepared ad hoc. Some of them comply with international standards, but what is important is to look at Section 11 and the relevant schedule that is applicable and see whether the minimum requirements under Section 11 are complied with. This is something that I will discuss during Q&A about ensuring a proper accountability framework in your organization through what we call, quote unquote, a data protection management program, through which compliance can be done by yourself, that means by the controller themselves, to ensure compliance. So this is a self-regulatory measure built into the Data Protection Act, which I will discuss later on during Q&A, about ensuring minimum compliance obligations that many of you are already doing to ensure that personal data of data subjects are adequately and meaningfully protected. Part 2 of the Act deals with the right of data subjects. It talks about giving access to information, withdrawing consent, right to object to processing, right to rectify, even the right to erase. But remember, these rights are not unilateral rights given to personal data, data subjects in relation to their personal data. You have the right, a controller has the right to refuse and reject it on multiple grounds, and there's a procedure for appeals for that purpose. Moving on, part 3 contains certain principles imposing additional obligations on controllers and processors. One is with regard to the appointment of a data protection officer. Now, there's a misnomer amongst many people whether this is a mandatory requirement for everybody. No. The criteria under which a data protection officer is appointed is clearly specified in the law. All organizations don't have to do it, but if you're processing data, you have to ensure certain minimum standards, and that is what is required. Appointment of a data protection officer, there are certain threshold principles in the law which we will take up in the Q&A. The most important point in the discussion of in relation to cloud hosting. I know many banks, financial institutions want to host products and services with cloud services, and there was a bit of gray area with multiple regulators taking different positions. So this law clears the ground basically for that kind of scenarios, imposing localization primarily to government statutory organizations that collect personal data, like, for example, immigration, identity card department, RMB, and such other entities, but they too can do it subject to approval from the future regulator. But for private sector, the regulatory cap has been taken off. But remember, we have provided flexibility through the new 26.5, section 26.5, giving multiple options for organizations to host data outside Sri Lanka. But remember, they would have to comply with minimum requirements in terms of compliance obligations under the Data Protection Act, like what we see happening across multiple jurisdictions. So I will run fast now since I'm run out of time. In terms of the other areas, the law provides there's a requirement to establish a new data protection authority that will have to be done in about 18 months time, or maybe latter part of this year or sometime next year. Its functions are highlighted here. And then, of course, some unique features which I thought I will flag. Unlike many other regulatory laws, in this particular law, the rules that will be published in Gazette from time to time will be subjected to a public consultation process. So I know we have SEC, we have central bank, and multiple other regulatory entities that publish rules, sometimes with public consultation, but sometimes not. This law hard codes it as a requirement for public consultation. Second thing is that we have tried to ensure that the future Director General of the regulatory authority will be selected through a competitive selection criteria based on criteria that will be published in the rules and such things like that. So this is kind of unique, but also what I want to emphasize in the context of what Shanaka mentioned, finally, on the fining aspect. Now remember, don't get too pushed off or scared by the 10 million fine. That is a maximum threshold. But before we come to fining and imposing penalties under the data protection law, and remember there are no criminal penalties, there is an administrative law remedy whereby inquiries will be held and directives can be issued by the regulator to comply and do course corrections to comply with the law. And if you fail thereafter, only penalties would get kicked in at a later stage, and that too after an inquiry. So with that note, Shanaka, I will stop for now. And I hope I didn't, I think I wasted my time a bit. Sorry about it. But that is it for the moment. I'll take the Q&A later. Thanks.
Thank you, Jayant, and great insights, and you create a platform for the rest of the speakers as well. I'm sure you will have more questions from the audience. So our next panel member is Mr. Nakul Chopra, from Associate Director from Ernst & Young Global Services. So Nakul, you have been trailblazing data privacy and related regulations across the region as well as globally through Ernst & Young. As Jayanta provided a briefing on the Sri Lanka Data Protection Act, how do you compare this with the global, regional, from Asia to European Data Protection Acts, or to the level of US Data Protection Acts? Can you do a quick comparison? Can you tell us how close it is, or what are the differences between these acts? And most of the participants are, I'm sure, have heard GDPR more. Over to you, Nakul.
Thank you, Shanaka, and CFA Society, first of all, for this particular lovely opportunity to be here and share my thoughts as a global SME in data privacy and protection. So, so I'll be happy to share some of my thoughts pertaining to these particular regulations. But before that, I just want to congratulate Sri Lanka to enact this particular privacy regulation and becoming one of the countries, one of the additional countries which will now comply with privacy regulations. So if we go by research, for example, Gartner conducted one recent research in which they published that by 2023, 65% of the world population will have its personal information covered under modern privacy regulations, which was there, for example, around 2016-17, it was around 10%. Then for example, by 2024, more than 80% of organizations worldwide will face modern privacy and data protection requirements. So all this is becoming possible considering that we are having a radical technology shift. And that's the reason why these particular new privacy regulations are getting enacted to safeguard individuals' data from unauthorized use, modification, and disclosure. If we talk a bit about European Union as well, European Union, the journey started with fundamental rights for privacy, then European National Human Resource Development Organization coming up with right to privacy somewhere in 1960s, 70s. Then a formal regulation in 1995, which was known as Data Protection Act or Data Protection Directive of the UK, and the European Union also followed. So that was introduced. However, from 1995 till we come to around this 21st century and 2018, etc. So we had seen a massive change in the way businesses work or in the way data is getting processed. So for example, earlier we used to have floppy drives. Now we have cloud computing, a massive storage. There are no storage limits on the cloud. We can store numerous number of information on cloud. Plus, with the advent of proliferation of smart devices, gadgets, Internet of Things, our entire homes are getting digitized or connected. We are into a connected world. We use modern day cab applications to book travel. Apart earlier, we used to go through travel agents, or we used to call a taxi driver for the same. With all this, personal data is getting collected, and in addition to this, number of new devices such as biometric readers have become commonly available, through which sensitive personal data is getting collected. In case it's a very known saying that in case you lose your password, you can refresh or reset it. However, if you lose your biometrics, your fingerprints or retina scans, if somebody saves, so it will be so easy for the person to navigate through your identity, access your detail, and commit so many frauds and or gain inadvertent access. So with the reason behind these privacy regulations are a new norm and are must requirement for countries which are adopting digital ecosystem, emphasizing on digital or cross-border global collaboration or transactions. For example, if Sri Lanka today wants to invite global giants to Sri Lanka, or Sri Lankan businesses wants to sell services outside of Sri Lanka within the European Union, Asia Pacific, or the United States, they would have to first and foremost comply with data privacy regulation. So this is one key checkbox which all need to tick before operating or expanding into the world. So with this background, I would just like to share some of the aspects pertaining to various countries' regulations. So one, European Union. As you all might be aware, European Union enacted GDPR, which replaced the prior Data Protection Directive 1995, which I was talking about. And this has become a most comprehensive data protection regulation considered as gold standard, and this came into effect on 25th May 2018. This regulation comes with hefty penalties like 2 to 4% of annual global turnover. Then there are some of the key requirements. And those particular requirements I would also like to relate with how Sri Lanka bill has got enacted, and those requirements still apply to Sri Lanka as well. Number one requirement, let's talk about privacy principles, core privacy principles, which require organizations to, for example, if as a customer, as an individual, I am giving my data to any organization, I would demand a privacy notice from an organization. In clear terms, they tell me what kind of information they want to collect from me, what is the purpose of collection of this data, how long they are going to retain this particular information, how this organization is going to secure this particular data, then then connect data protection officer or organization for any grievances. So these are the bare minimum things you would require in a transparent manner. And privacy notices don't need to be, say, long pages. For example, 6-page privacy notice nobody will bother to read, and hence requirements for transparency have kicked in for organizations. So this one particular requirement pertaining to GDPR on okay, this one particular requirement pertaining to GDPR is also applicable to Sri Lanka regulation. Then we come to the second regulation, second requirement, which is data subject access rights. As data subjects, we can demand organizations what kind of data is getting processed, how do we rectify this particular information in case we want to subject or limit automated decision making, or in case we have we no longer want to be associated with the organization and want organization to delete our data, we can demand right to forgotten or right to erasure. So these are data subject rights which are fundamental to EU GDPR as well as with Sri Lanka privacy regulation. Then GDPR requires data controllers, which is organizations which primarily collect or define means and purposes of processing, to disclose data breaches directly to the supervisory authority or / data protection authority. In addition to this, GDPR also has an additional requirement to report data breaches to the individual also. So with this particular requirement, it resonates same with Sri Lanka privacy law. And one particular point I want to mention, within Sri Lanka privacy regulation, a number of things have been mentioned right now, but have been also left to the data protection authority, which will get formulated and will bring some guidelines as well. For example, one of the questions which the panel we received in the panel as well pertaining to security requirements or specific guidelines, or for example guidelines to report breaches, or what are the forms which are going to be used. For example, right now bill talks about reporting data breaches. Tomorrow when the law advances or when data protection authority gets formulated, the authority will provide you some kind of template to report data breaches, email IDs to report data breaches, and there may also be some FAQs, frequently asked questions, which you can utilize in order to answer or concern any queries. Then we have requirements to appoint data protection officer in certain cases. So likewise in GDPR, we have similar requirement over here. Then requirements for consent collection for processing of certain types of data, or defining necessity or legitimate or legal obligations for processing of the personal data. Then conducting data protection impact assessment. Both aspects are covered there in GDPR as well as in India, in Sri Lanka PDPB as well. Then requirements for maintaining records of processing activities. So these requirements are also there. For example, every organization which is processing data about individual would be required to keep a record, which would include, for example, what data they are collecting, what is the purpose of processing, whether it is a legitimate interest, legal obligation, or consent obligation. Then what are the systems on which data is residing, with whom all this data is getting shared, is there a cross-border data transfer, retention period, and why do organizations require to maintain this particular record? Considering that an organization will have numerous number of data subjects or individuals, unless they have a central place or they have a record of this particular processing, they will not be able to respond for DSAR, data subject access right. For example, I as an individual tomorrow asks any insurance company or a bank that I want my data to get deleted. So unless they know individuals data is residing on 10 IT systems or three physical forms, they will not be able to act upon. This is the reason why we concentrate on organization preparing data lifecycle maps or records of processing activities, which act as a handy source guide to remove the data or act upon the data or modify data. For example, you may change your name as well, or you may want to change your address. Sometimes what happens, we give data to financial institutions, we have changed our address, but still we are receiving communication to the old address. So what has happened is we don't have centralized database or centralized records of processing activities, due to which data has not got corrected. So these are some of the requirements which GDPR brings on the table, and similar requirements are mentioned in the Sri Lanka Privacy Bill. Then I would briefly like to cover, not going into much details, but other countries nearby, neighboring, or within other regions of the globe, how they are progressing with the privacy regulations. So to talk about Asia Pacific related, so maybe Australia. So Australia has their own Privacy Act 1988. So there is a requirement which has came in October 2020 for certain modifications which have been proposed for this particular regulation. Then China in the year 2020, 19th November 2020, formulated PIPL, which is Personal Information Protection Law. This law has also become applicable from November 2021. So China has China law also, to an extent, it meets the global privacy requirements. However, China has introduced some specific cross-border data transfer conditions and mandates organization to maintain some registers or take prior permissions before transfer. Then we have Hong Kong, which has also come up with a privacy ordinance. India is also in the final stages of enacting a personal data protection regulation. Year 2016, India 17, India came up with right to privacy as a fundamental right. There were changes made in the constitution, and then there are a couple of versions of bills which have been tabled for the cabinet approval, which are going through some consultation, and very soon India, as your neighboring country, will also have a formal privacy regulation. Then Japan enacted a privacy regulation which is called as Act on Personal Information APPI. South Korea, then South Africa, 2 years back, they released the pending provisions from their earlier 2013-2014 privacy regulations. So this is the scenario of Asia Pacific. Now, I would like to just touch upon United States as well for a few minutes. So United States, as at the present juncture, they don't have a comprehensive data protection regulation for entire 50 states over there. So they have certain laws and regulations. For example, they have HIPAA, which is for Health Insurance Portability and Accountability Act. Then they have GLBA, which is Graham Leach Bailey Act for financial products and services. Then they have certain requirements for children coming from COPA, which is Children Online Privacy Protection Regulation. Then they have ECPR, which is Electronic Communication Privacy Regulation, which is more relevant to telecommunication or network service providers, etc. Very few states in the US, which is 3 states, have enacted privacy regulation, a comprehensive one. So one is California, CCPA. Then we have Virginia, which is VCDPA. Then Colorado. So out of 50, almost 3 states have yet comprised a formal privacy regulation. But I would not like to mention, not like to discount that United States has less privacy than other countries. So there is a typical way of handling privacy over there through surround regulations or other specific requirements for data security breaches, or Federal Trade Commission also is pretty active over there on private sector and public sector both, which levies certain sanctions to organizations as well. So maybe I'll take a pause over here, but just want to reiterate this particular aspect that Sri Lanka privacy regulation is in line with the global privacy regulation. And Jayanta also mentioned about consultations which Sri Lanka privacy regulation has gone through, which is your OECD or APAC privacy principles, or GAPP, which is globally accepted privacy principles, data protection directive, Singapore privacy regulation, and EU GDPR. So it's a culmination of all regulation, but definitely a global standard, or gold matching the gold standard to boost overall economy and cross-border data transfer, and much better reliance on organizations to whom data will be shared by individuals and by outside organizations as well.
Thank you, Nakul, and thank you. That was very insightful, and I'm sure we have more questions to you. Thank you for that insights. Our next, I would like to invite next Ms. Swadini Vikramasinghe, Head of Compliance, NDB Capital Holdings Limited. Swadini, I would like you to be more focused on the financial services industry, and whereas possible, some of the practical aspects that you're seeing in this act. I'm sure you would have started certain initiatives on this, so you will have a lot of ideas in terms of practical gap analysis to implementations of that within the organization. So my first question to you is, how do you manage this transition in the financial services industry? Do you think the sector is ready, or do you think the financial services sector should start from ground zero to make themselves compliant with that?
Thank you, Shanaka. Sorry. Thank you, Shanaka. And I want to thank this CFA Society for organizing this webinar and for this opportunity, and also having me on the panel. So in responding to your question, Shanaka, I think in terms of, if you take it from an industry perspective, the financial services industry is mostly a regulated industry. So already there are certain things in place, especially if you take banks. Now, one of the principles enshrined in this law is confidentiality and integrity of information, so of data. So that those kind of things are already embedded in certain institutions in the financial sector. Mostly that comes from the regulated environment. So I would think that the transition would be they would be more familiar with the transition and be able to handle that easier in comparison to an industry where they might have to start afresh. So for example, now, if you focus something on confidentiality, right? Section 77 of the Banking Act has provisions on confidentiality and how confidentiality should be maintained in banks. Now, even if you take the capital market industry, say, for example, the stock brokering firms or investment management companies, client information is secured and protected. So what you would need is maybe to meet the standards prescribed in the law, you might have to improve certain things, and especially in terms of information security systems. I think already regulated environment, or even in the financial services sector, any other company, you would have certain systems in place in how you store information, how you control access to that information. Those systems are already in place. In fact, you might even be doing vulnerability assessments on your information systems to check what weaknesses are already there. So these kind of things might already be in place. So from a practical point of view, I would think, obviously, there are certain thresholds that have been fixed in the law, that certain standards that will have to be met. And that, of course, there would have to be an upscaling of what is already in practice. So I personally feel that the transition would be a little bit more smoother for the financial sector, because the financial sector would already be very conscious about some of the principles that are already enshrined in this law. But of course, there might be, and I think one feature in the law which we need to be really grateful about is that the law does not prescribe the same standards or the practices that have to be met for each institution, because it has a self-governance process that would allow you to sort of do an assessment of what sort of data you're processing, how frequently you're processing this data, and depending on that, you can design your own program to meet the basic standards that is prescribed in this law. So I would think, to that extent, the transition, the law gives the institutions that level of flexibility, and I think that would sort of make that transition a lot easier also in the financial services industry. Thank you, Shanaka.
Swadhi, thank you. So I remember even Jayant touched base on this flexibility and the section 12 of that. So what you say is this program the flexibility will be applicable to different sectors at different levels, or how that applicability?
Well, see, Section 12 has a clause which says that you can design depending on the scale, the nature, and the volume of the information that is processed. So what the standards, basically you have to meet the standard or the threshold set in the law, but how you meet that, to what scale you need to sort of have your measures in place or the safeguards in place would depend from company to company or institution to institution. Say for example, what a bank needs to do, depending on the nature of their operations, the scale of their operations, a brokering house may not have to meet that same standard.
Right.
But of course, the threshold has to be met. You have to maintain confidentiality. You have to ensure there is a lawful purpose. Either you have to get consent, or there should be a legitimate interest for why you're collecting that data. So those thresholds will have to be met. But how you meet that, the program can differ from one institution to another, depending on the scale of the operation and the kind of risk that will come to the data subjects in processing that data.
Thank you very much, Adini. Thank you. We'll come back to you again. Dinesh, you are there connected? Dinesh? Yeah, not very much audible. So Dinesh,
how about now? Can you hear me?
Now good. Yes. So Dinesh, as the president of the CFA Society Sri Lanka, what does the new Data Protection Act means to your members? How are they in the investment management industry will get benefited, or will try to use this act to become much more compliance?
Yeah, so I would thank you for the question, and I would also like to first thank Jayanta for the very comprehensive overview of the act which he provided. From going by his presentation, there's quite far-reaching implications on the use of personal data. A lot of our members are engaged in the investment management industry, which means, amongst other things, collecting the personal data of their clients and designing customized investment plans to meet their objectives and executing those plans, then reporting the performance to their clients. So I think so far they have been complying broadly with regard to the AML KYC requirements, mainly by the FIU of the central bank. But now they have an added burden to comply with the data protection requirements. So I think it's a good time that we are having this discussion today. So they have the time to think on how they are going to manage the data and comply with their requirements under the Act. And I think we will also need to have a lot of ongoing training and support to our members to guide them in the correct direction.
Thank you, Dinesh. Thank you for that. So we have a lot of questions which are coming through our Q&A board. I'm sure the panelists also could see that. Jayanta, I would like you to take one question. I thought it's related to you and what the law states. So particularly this question is about a particular unique scenario, Jayanta, where the data processor is a multi-tenant cloud service. I'm sure hosted somewhere around the world, could be Azure, could be AWS, etc. So that's the cloud service provider, which we host data, and we host data of, let's say, Sri Lankan individuals. And then we identify a data breach, a compromisation. And then under that data breach, which law will be applicable? Is it the Sri Lankan Data Protection Act, or is it the GDPR or any other global acts will be applicable under this scenario?
Thank you, Shanaka. That's a very interesting question. In fact, the way we can answer that is also dependent on the controller processor relationship that led to the hosting of that data outside the country, right? So the fundamental premise under this act is, as I said earlier, we have provided greater flexibility than before compared to all the different versions that we had right from the beginning. The current version that was enacted by Parliament contains greater flexibility, right? To enable a controller in Sri Lanka to host data of their clients in the cloud. But in doing so, there has to be certain minimum standard compliances that needs to be met, including obtaining, complying with consent obligations, complying with performance of contract kind of scenarios, and so on and so forth. Now, having said that, Shanaka, the issue that you raised about possible data breaches in a multi-tenant cloud environment, remember those tenants or the cloud environments would be deemed to be processors within the meaning of this act. Okay, so as a processor under this act, what needs to be kept in mind is the fact that the controller processor relationships have been defined. So there is a provision here in this act saying that where a processor is engaged in processing activities on behalf of a controller, the processor shall ensure processing activities are carried out only on the written instructions of the controller. So I would fall back on that situation to say, in answering that question, Shanaka, it all depends to what law the controller is bounded by in that controller processor relationship. So if the controller is a domestic player and has entered into a controller processor relationship with a party which is the party hosting the multi-tenant cloud facility, right? If instructions have been given, and then we have in section 22 facilitating the controller to carry out compliance audits, etc. So compliance as a service, all those minimum safeguards have been followed. If there's despite that, if there's a data breach, remember in a data breach scenario, the notification obligation in a data breach scenario is basically governed by rules, but it is founded on the principle that controller and processors both have an obligation to inform the regulatory authority about that breach, and the regulatory safeguards and liabilities under this act would get triggered both on that controller processor relationship. So there is a requirement to notify, but I would like to flag the point. It's not a plain and simple answer, because the circumstances where the authority shall be notified of a data breach, where it affected the data subject, etc., has to be defined in the rules, right? And those rules will govern that. Rules will be done when the regulator is established. But remember, this law is cross-border in nature. Given the interoperability framework that we are talking about, in that example you cited, it would attract liabilities under this act, right? So safeguards will have to be ensured to make sure that controller processor relationships are properly governed, and so many other factors which I would not have time to explain now, but these are matters for compliance, risk management folks to take note of especially with reference to section 22 and 26. Thanks.
Thank you, Jayantha. Thank you. We have a few more other questions. I'll take another question. Quite interesting. I think this is a common question for many people today. Maybe I will ask Nakul to give us an answer to that, because Nakul, you have been in the region, you have seen GDPR, you have seen many other acts around the world. So I think you're the best person to answer this question. So the question is about, if an organization, I'll reword the question. If an organization in Sri Lanka is already compliant with the Sri Lanka Data Protection Act, can they become compliant with GDPR, or how easy it is to get that, or is there any workarounds to be complied with the GDPR while you're in compliant with the local Sri Lanka Data Protection Act? Nakul?
Sure. Thank you, Shanaka. And this is an extremely pertinent question for organizations which are operating in global scenario, operating out of multiple countries, either in Sri Lanka or in European Union, want to do business in Sri Lanka. How do they comply? So first, I'll take scenario of an organization which complies with, for example, Sri Lanka privacy regulation, and in case they also want to ensure what is missing in terms of compliance to GDPR. So first point we should all note is every regulation comes with some of the specifications or callouts. For example, if EU asks organization to prepare records of processing activities, or share data subject access rights, or report data breaches. So there would be requirements of data breaches, there would be requirements of personal data inventory, records of processing activities, but there may be certain specifications which will change from regulation to regulation. For example, template used for Sri Lanka may be different, GDPR may be different. And similarly, when you are, for example, requirements for registration of the DPO. So within Sri Lanka, there may be, for example, 4 parameters A, B, C, D, and in GDPR, there may be 2 or 3 parameters, yes, similar, but 1 or 2 might be different. So when you have achieved compliance to Sri Lanka privacy regulation, which is precisely in line with the requirements of EU GDPR, you are almost around 70 to 80% there. You need to put an additional 20 to 30% effort based upon the in-scope regulation of the country. And in regards to this, would like to also add upon organizations which really want to operate in a global manner. And like one particular question which Jayanta also specifically answered pertaining to cloud service providers. So cloud service providers like Azure or AWS, Google, so they are formulating some kind of a global privacy policies, and then they come with specific addendums or amendments to call out specific nuances or specific requirements for in-country regulations. But 80% of the work they are completing with one particular privacy policy or one particular standard, and then they have specific addendums or specific sections which you might use for complying with your in-country regulation. So this is the approach organizations need to follow. For example, if all privacy regulations or mature privacy regulations require privacy notice, transparent privacy notice, conducting data discovery exercise, classifying information, formulating an information security policy, getting compliant with ISO 27001, or focus on cybersecurity to prevent modern day thefts, etc., securing your web applications, log monitoring, database log access, etc. So you have to put all this effort for all the regulations. 10 to 20% is something which may be specific to a particular regulation which you might be required to achieve. I hope that answers the question.
Thank you. Thank you.
Shanaka, can I just add something to what
Sure.
Nakul said? Thank you very much, Nakul, for that excellent response, which in a way reminded me of something which I may have not clearly brought out in my first part of my presentation. Shanaka, 2 things I just want to highlight. Firstly, in relation to compatibility with GDPR, I just want to emphasize that in the discussions that we had in the latter part of 2019, that is October, November 2019, and thereafter 2020, mid-2020, despite the COVID impediments, and then last year, first quarter and the last quarter, we engaged in addition to the multiple local reviews that were done in Sri Lanka. We had the bill reviewed by international experts from Australia, Japan, and few countries like that. But most notably, European Commission authorities, especially the division responsible for cross-border data flow, did an extensive review of our draft. And I also managed to get the benefit of an expert from UK as well, so that our common law trends on constitutional safeguards as well as commercial law principles will be kept without attracting impediments. So what I want to emphasize is that European Commission in the evaluation found compatibility and said that we have made the minimum standards, and then we have put in some self-regulatory measures. But in the context of what Nakul said, we also want to emphasize that international operators such as Google, Facebook, AWS, Microsoft, all of these players through Asia Internet Coalition was engaged in a extensive discussion to see how best they would comply with this law. And I just want to mention, as per section 21, when processing is carried out by a processor on behalf of a controller, it is the controller's obligation, that is, the financial institutions here would have the obligations to use processors to ensure provisions of appropriate technical and organizational measures to give effect to the provisions of this law. So which would mean exactly in line with what Nakul said, that all these organizations do minimum standards. They have compliance frameworks where they provide for minimum technical and organizational measures to comply with international standards, and they would add addendums. And in adding an addendum, we brought the framework in line with those standards, so that with minimal adjustments, because we are a very small country, we have to promote this as a services sector, we would ensure that with a simple clause, they could say, okay, Sri Lanka meets, for Sri Lanka, this is the standard in line with the global standard. So we kept to the foundational principles based on international principles, so that all of them would be able to engage customers and other large players in Sri Lanka without any impediment. Thanks.
And Jayanta, just to add one additional point which might clarify things is with regards to adequacy decisions. So Sri Lanka privacy regulation has mentioned in certain areas about adequacy decisions or countries which will be deemed to be adequate. So most likely once the Data Protection Authority gets set up, they would consider countries who have already have global regulations for a free trade or free cross-border data transfer without worrying about signing contracts or much more stringent requirements pertaining to safeguarding or ensuring that your processor ensures or provides appropriate safeguards. So these aspects will be quite pivotal in the growth or rapid adoption of privacy bill, which might otherwise think like an age-long efforts or multi-year journey.
Thank you. Excellent point. Thanks.
Thank you, Nakul and Jayanta. That was very, very good.
Shanika, can I just add one point to I think what the panelists have already said. I think the law has been designed in such a way that there have to be rules in the implementation for the authority to specify further. So I think that flexibility has been really built into the law. So that also gives the authority that opportunity where there is a necessity that you need to comply to the level that GDPR requires for certain industries or for certain controllers who might have to process information, process data that will require that level of compliance. I think the authority has that flexibility.
Thank you, Swadini. Swadini, I have one more question for you. Yes. Now we all see, unsolicited messages, bulk messages, group messages, in email form, WhatsApp form to short messaging form. So what do you think, what sort of impact you could have in sharing these databases of personal data for the purpose of promotional activities?
That's an interesting question. I think if you take your phone now, that's what you get most of the time as messages,
exactly.
right? So now under the data protection, the Personal Data Protection Act, one aspect is that basically for your information to be transferred to a third party or used for promotional purposes, there needs to be consent for that. So you can't really be sending unsolicited messages. And even if you do send out sort of value additional services, promotional messages, etc., there has to be a link built in or a way people can unsubscribe to such things. So those things have to be built in. And I think from a point of view of groups, where you sort of function together with related companies, there is a tendency to promote the services of related companies. So people may share databases for that particular purpose, and you can't now do that without the express consent of the data subjects. You can't really share those databases. So that measure is really is guaranteed in the law, and you can sort of protest about it, and that will be a data breach if there's no consent. Shanaka?
Sorry, I was on mute. Sorry about it. Right. So thank you very much. We have one more question, quite interesting. I think Jayanta would be the best person to take care of it. Jayanta from Lakmal, one of my close friends at CRIB. Quite interesting question. CRIB is permitted to collect data, personal data, through lending institutions, and then of course they use this data to take certain, in a way, build certain matrices, build certain scores, and then they basically transfer this data back to those institutions. So the institutions could take decisions based on this personal data that they collect and they process, and maybe they share it with those institutions. So the Act permits this. The question is, will this entire business of a CRIB be impacted based on the new Data Protection Act?
No, thank you very much, Shanaka, and thank you very much, Lakman, for that excellent question. Basically, if you look at that set of principles I outlined in one of the slides, by the way, the slides will be shared with you, Shanaka, so that you can distribute it to all the participants. If you look at those principles I outlined, principles of data protection in part 1, and I gave reference to the section 5, which talks about what constitutes lawful processing of personal data. And I referred to Schedule 1, which mentions each of the conditions that one of which needs to be satisfied to do lawful processing. In addition to consent, so consent is not the only reason. In addition to consent, processing that is necessary to be done in compliance with the legal obligation to which a control law processor is subject to under any written law would also amount to lawful processing. So to connect it to the CRIB scenario, if the CRIB law mandates the Bureau to collect credit data from institutions, synthesize credit data in a meaningful manner, disseminate credit information back to lending institutions for credit underwriting or monitoring purposes, etc., etc. That is permitted activity under the CRIB law. When they do that function, they would be able to interact with the lending institutions in a lawful manner, and the lending institution sharing that information with the CRIB would constitute lawful processing within the meaning of Section 5, read with Schedule 1 of the Data Protection Act. So there is no contradiction. It synchronizes
And in view of these laws, the CRIB Act, then we have the Financial Transactions Reporting Act, we have the Money Laundering Act, to several other laws which are interconnected. It is in view of that we formulated this in such a way to provide multiple options through Schedule 1, right?
Thank you, Jayanta. Thank you for that note. Nakul, I would like to, since time is quite limited, we are reaching the end of it. So maybe a quick answer from Nakul with the experience you have globally and regionally, so supporting clients. As you know, Ernst & Young, we help many clients regionally and globally to align with these acts. So, and you're driving that team, you're executing these engagements across the region, across the world. So in a quick form, can you tell what kind of approach the clients or participants connected here, what is the recommended approach to embark on this data protection or data privacy journey in Sri Lanka, Nakul?
Sure. Thank you, Shanaka. So glad to share some of the perspective while it may not be enough in the remit of time. But maybe I'll share how organizations typically begin their overall privacy journey and they subsequently mature. So step one is organization needs to determine what are the laws and regulations to which they need to comply. For example, we were discussing about cloud service providers or global organization based out of Sri Lanka operating or doing some activity pertaining to EU Gdpr or US, etc. So they first need to conduct a thorough assessment to identify what laws and regulations are applicable. Then understand what kind of personal data we process, what are our data collection points, to whom all we share personal data for processing purposes, where do we store data, what kind of accesses are available to the data. So we don't need to go into a fixing mode while we are doing assessment. So first we identify all the forms within organization, types of data that is getting collected. They may be manual, physical, or website forms. Then different sources of the data are identified at this particular first stage of the data lifecycle, which includes data collection. Then we move towards processing of the data. What kind of different processing is happening? Users who access data, they download Excel files, they share with third parties. What are the systems through which they are accessing? Are they secured, unsecured? Do they keep the information in an accurate manner or not? So a thorough privacy impact assessment for an organization is conducted to identify roles and responsibilities, policies, procedures, security aspects, then data governance related aspects. And outcome is like a privacy gap assessment report with a recommendation to organization stakeholders what they need to do with some milestone as well. So for example, based upon the assessment, for example, certain organization may be doing well in cybersecurity or may already have implemented some global requirement considering their clients required to do that. Most of the times, like if you are working with a global giant, the global giant might ask all their subsidiaries or all their respective organization to implement bare minimum privacy standards. So with this, the job becomes a bit easy. So we'll get to know how long the organization is going to take. And then we start designing policies and procedures. So second stage is designing, wherein we formulate personal data, data privacy or internal privacy policy, procedures for records of processing activities, data subject access rights, or identify or use certain tools for data discovery to identify what data is getting stored on the system, where structured data is there, where unstructured data is there, or what are the typical third-party vendors we use within our third-party ecosystem or existing ecosystem. And once we have this particular design ready, then we start mobilizing, which is implementing. For example, updating our privacy policy online, then pushing in a consent mechanism. We may want to use a privacy governance tool to put a cookie banner on our website or provide cookie preferences to users. Then to third parties, we start communicating like these are the privacy standards you should start implementing, or this is how you will be audited on 6 monthly basis or an annual basis, depending upon the criticality or the data which you are processing. We start conducting privacy assessments or privacy impact assessment for business processes, providing guidelines and giving them steps to implement. Then we conduct a number of sessions, because data literacy or privacy awareness is paramount to the success of the privacy program within organization. So we roll out privacy awareness programs through CBTs, which is online training modules, computer-based tests or trainings. Then we conduct some workshops with individuals from departments. For example, human resource department, we need to train them how they collect HR data. Marketing, we need to talk specifically about customer data. Manufacturing, we might want to limit our talk on data, considering they have little personal data to process. So within their remit, we are going to tailored privacy awareness sessions for organizations, then rollout of modern day tools and technologies. When all this is done, when an organization achieves a particular compliance, then we go in a sustain mode wherein we do a periodic assessment of the privacy program, or privacy becomes a third line of defense, which is internal audit teams start reviewing privacy. Because at the moment, if we have not compliant, internal audit team is going to come up with a red report. So once we have certain things implemented, then probably it would make more sense for third line of defense within organization to act upon and provide inputs to the board on how privacy program is moving. And why this is required is because privacy risk, for example, in Sri Lanka also we have million rupees penalties. So because of the penalty, privacy becomes one of the most and pertinent or major risk to the organization, at least coming in top 5 risk to organization. Other risk may be your brand, reputation, or other financial loss or corruption, etc. So privacy is one of the top 5 risks for most of the matured organizations today. So with this brief, maybe I'll take a pause and Shanaka, again, give back the stage again to you.
Thank you very much. Swadhini, very quick question to you. In a practical sense, is the law overbearing to the financial services industry?
That's an interesting question, Shanaka. I think my first response when I was responding to your first question to me, I said the transition would be a little bit more easier in the financial services industry. But having said that, I must also note here that there can be a cost of compliance,
exactly,
like for smaller scale institutions. So that is why it's important when the Data Protection Authority in implementing this law takes cognizance of that fact, that the data breaches and how you meet that threshold, what sort of measures that each company should be taking should be in proportion to their scale of the operation and the nature of the operation and the level of how they process and whether there are periodic reviews. All of that should be taken into consideration, and Data Protection Authority has to be mindful when they come out with the law rules, because as I think as Mr. Jonathan Fernando noted, there will be consultations when the rules are made. Then the rules are going to be formulated. So I think it's very important for the financial services industry to be engaged with that process. So I would not say this law is going to be completely overbearing, but it has to be balanced, and it is also in the implementation of this law and through the rules on how you manage the impact of this law.
Thank you, Swadhini.
Shanta, can I add one thought? Thanks to the excellent thoughts given by Suhadini. In one matter to remember in terms of imposition of fines by the authority. So if there's a contravention, first step is a directive, which is after a formal hearing, and that is an administrative law measure available in many financial laws, including the Payment and Settlement Systems Act that has been imported here. If there's a violation of the directive, only the penalty would get triggered thereafter, and that also after a hearing, and so there are thresholds. But in imposing a penalty, it's a point that I was reminded in view of what Suhadini said. In imposing a penalty, the Data Protection Authority, the regulator, will have to take into consideration the nature, gravity, and duration of the contravention, taking into account the nature, scope, or purpose of processing. So the size of the business, the nature of processing, those are factors should be taken into consideration under 39. And going back to 12, I just want to mention that if you have a self-governance regime, I'm mentioning this in the context of a smaller organization, which in order to manage your cost of compliance, if you have a data protection management program and comply with the minimum criteria described in section 12, that is to have a mechanism to ensure that data is duly cataloged and maintained to reflect the data protection principles, and there are appropriate safeguards with regard to access control procedures and so on and so forth, and there is a minimum standard of governance and have a internal oversight mechanism, for example. If those minimum standards are met, then in imposing a penalty thereafter, the regulator has to look at how effective the data protection management program has been implemented, whether it's a big or small business, right? So that's the point I just want to flag. Thank you, Suhadini, for bringing that. Thank you.
Sure, thanks, Jayanta. Jayanta, I want to continue and wrap up this with one last question to you, because I thought it's an important question that has come through the Q&A. If I reword it, you know, how will this Data Protection Act impact the current Right to Information Act?
Yeah, sorry. So this was interesting debate that came out in the very first draft in June 2019. And that is why right through June 2019 through October, September, October, there were multiple rounds of public consultations. And we even engaged with the Right to Information Commission, the legal division of the RTI Commission, to ensure that this law would be consistent and would not contradict the RTI Act, right? And we went one step further just to validate what we were doing. We got the benefit of a group of independent panel. We got an independent panel, a review panel appointed, which was co-chaired by well-known international law and constitutional law jurist, Professor Savitri Gunasekara and Justice Chitrasiri, Parliamentary Ombudsman. And we went through multiple iterations to ensure that there is no conflict, right? And then the Bar Association also did the validation latter part of last year and confirmed that we are not contradicting any framework under the RTI regime, and that is why the Bar Association did not challenge this bill. Now, that said, Shanaka, I just want to emphasize how this would work in line with RTI. So again, going back to the lawfulness principles relating to lawful processing of personal data in relation to a public authority, which is subject to RTI Act, how this would work is if you make a request to a public authority for information under the RTI Act, and if this information involves personal data related to something or some activity in that public authority, right? If a question arises whether the public authority can release that data or not, if you look at the principles of lawful processing, one of the conditions is processing that request in compliance with a written law obligation imposed on that controller. So that controller will look at this and see, okay, there's a requirement to comply with RTI Act, and therefore that information would be released, justifying one of the conditions under Schedule 1. Simple as that. So there is no contradiction. This law is consistent with the RTI Act. And I think there was a bit of a misunderstanding because I think the language not gone into detail. And to make matters even more clear, we have added a very special international law framework in Section 40 based on international human rights law and constitutional law principles, whereby the protection of rights and fundamental freedoms of persons, particularly the freedom of expression and right to information, are guaranteed as overriding principles under the derogation procedure in 40 of this Act. So we have gone a little bit beyond other laws. It's a matter of explaining to people about the safeguards and how this works. Thank you, Shannon.
Thanks a lot, Jayanta. And there are more questions. that has come up, but in the interest of time, I want to wrap up. I'm already about 9 minutes late. Very sorry for that, actually. So if there's more queries, please don't hesitate to reach Ernst & Young or CFA Society Sri Lanka. I would also like to take this opportunity to thank all our speakers, Jayantha, Nakul, Swadhini, Dinesh. Thank you very much. And it was an honor and a privilege to moderate the session with you today. I must also thank supporting individuals and organizations today helped us to make this a reality. So thank you very much, everyone who joined today. Thank you very much. And we are looking forward to future engagements with you and all the very best to you. Thank you very much.
Thank you. Pleasure.
Thank you.
Thank you, Shanaka. Thank you.
Thank you.
CFA. Thank you.
Thank you, Shanaka. Thanks to the panel as well. Have a good evening. Bye.
Bye. Good evening.